Assalamualaikum. My name is Samashman bin Muhammad Rusli and my matrix number is 2058.
Hi, my name is Muhammad Arif Daniel bin Muhammad Afandi. I'm from DKM 3B. My matric number is 01 DKM 20F 2038.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Mahathir bin Maidin from class DKM 3B and my registration number is 01 DKM 20F 2071.
Assalamualaikum to my friend. My name is Shafari Aiman bin Samsul Azhar. My registration number is 01 DKM 20F 2056. And today we are going to discuss about case study.
Case study A. Engineer A works for a huge industrial corporation that does a lot of work on defense projects. Engineer A's responsibilities include reviewing the sufficiency and acceptability of designs for material delivered by subcontractors, among other things. Engineer A informed his supervisors of concerns he discovered with specific submissions from one of the subcontractors through memos, urging management to reject the work and order the subcontractors to fix the defects he described. Engineer A's remarks were dismissed by management, notably his suggestion that a certain subcontractor's work be revised due to Engineer A contention that the subcontractor submission constitute undue cost and time delays. Engineer A's management superiors exchanged more memoranda, and after continued disagreement between Engineer A and management on the issues he raised, management placed a critical memorandum in his personal file and subsequently placed him on 3-month probation with the caveat that if his job performance did not improve, he would be fired. Engineer A has maintained that his company has a responsibility to guarantee that subcontractors produce equipment in accordance with the requirements as he perceived them, and therefore save significant defense spending. He has asked for an ethical evaluation and judgment of the legality of his actions, as well as the extent of engineers' ethical obligation in such situations. For Section 2(1)(a) of the Code of Ethics, engineers must always remember that their first and foremost responsibility is to safeguard the public safety, health, property, and welfare. If their professional judgment is overturned in a situation involving the public safety, health, property, or welfare, they must tell their employer or client, as well as any other authorized authorities. For Section 3(2)(b), Section 3(2)(a), and Section 3(2)(a), engineers are prohibited from completing, signing, or sealing plans and or specifications that are not of a design that is safe for the public health and welfare and meets established engineering standards. If the client or employer persists in engaging in such unprofessional behavior, the project will be reported to the appropriate authorities and the client or employer will be removed from the project. Discussion. In case 65-12, we look at a case in which a group of engineers thought a product was dangerous, and we found that if the engineers retained that belief, they were morally justified in refusing to engage in the product's processing or manufacture. In such circumstance, we realized that the engineers' actions would very certainly result in their dismissal.
Firstly, we identify a circumstance in case 61-10 where engineer object to the design of commercial product, but there was no matter of public health or safety. We conclude that this was a commercial discussion for management and that the engineer had no right to criticize it on ethical ground. The portion of the code in question is about plan and specification, that not of a design safe to public health and warfare, and it relate that requirement to engineers, ethical obligation to notify the relevant authorities of the hazard and to resign from further employment on the project. Secondly, that is not the case here. The claim is based on poor planning and the unjustifiable use of public monies, not on a threat to public health or safety. We could dismiss the case on the narrow ground that the code does not apply to claims that do not involve public health or safety. But we believe that is an oversimplification of the ethical obligation of engineers engaged in activities that have significant impact on defense expenditures or other significant public expenditures related to warfare. Okay, next we talk about case study B. Firstly, Code of Ethics, Section 1.4. Engineers in the fulfillment of their professional duties shall act for each employer or client as faithful agent or trustees. Secondly, Section 111.4. Engineer shall not disclose without consent confidential information concerning the business affair of technical process of any present or former client or employer or public body on which they are served. Thirdly, Section 111.7. Engineer shall not attempt to injure maliciously or falsely, directly or indirectly, the professional reputation, prospect, practice or employment of other engineers. Engineers who believe others are guilty of unethical or illegal practice shall present such information to the proper authority for action. Fourthly, Section 111.8. Engineers shall accept personal responsibility for their professional activities, provided, however, that engineers may seek indemnification for service arising out of their practice for other than gross negligence, where the engineer's interests cannot otherwise be protected.
Sarina may have a contractual responsibility to sign and seal the construction document before leaving business. If she was in control of project while there, she may be in violation of contract if she does not sign the seal, the paperwork, and firm may sue her. If Sarina is a licensed engineer in the state where the project is situated, she may be required to sign and seal the paperwork. She may not be required to sign the seal paperwork if she is not a professional engineer, but she might still be held accountable for any errors and omissions in the building document. A key ethical concept in the NSPE Code of Ethics in the engineer commitment to bear responsibility for professional service. Engineers as professionals must bear responsibility for professional service provided by them or under their direct personal supervision on the general basis. This might include work done for the benefit of a client, design work, report, plan, specification and work generated by the engineer that will be presented to a public body for approval, depending on the nature of the job and other requirement. Sarina has the option of requesting payment from business A in change for signing the paperwork, but firm A is not compelled to do so. Sarina, on the other hand, was unethical in refusing to sign the construction agreement. Sarina has a professional and ethical responsibility to guarantee that the work she has left behind is up to code and complies with all safety regulations. She might be held responsible for any flaws or omission in the construction documentation. Engineers who work for one business and then for another are not relieved of their professional obligations because they no longer have a direct link with their prior employer. The job they did for them is not less their own. Once a professional render professional service on behalf of a client, the professional is duty bound to make certain that the work done responsible and professionally and the client interested are protected and preserved.
Okay, let's go through about case study C. In general, all engineers are required under the NSPE Code of Ethics to respect the reputation of fellow engineers in their professional pursuit. Engineers should communicate with their colleagues in all professional matters with honesty and directness. Individual engineers frequently have both a professional and a business connection with their professional colleagues, necessitating the use of sound of judgment and prudence. See NSPE Code Section 3.7. The Board of Ethical Review has never had to deal with a situation like the one in the case. BER, the problem citizen of one engineer by another was addressed in case 84-1. Although the facts were considerably different, Engineer A needed the service of structural engineer in another jurisdiction and self-assistance from a college in that jurisdiction. Engineer B, as board, understand the circumstances. This is perfectly acceptable and does not violate the code in any way. Engineer A only dubious move, it appeared, was then one confront with Engineer C. Less than satisfactory professional performance. Engineer A informed Engineer B of the situation, while Engineer A contact with Engineer B may have been an appropriate manner of delivering input. Engineer A should have addressed his concern about Engineer C to Engineer C as well. Engineer A may have investigated alternative means of direct communication if he was having trouble contacting Engineer C. Engineer A may have made his feeling known to Engineer B, put the head on Engineer C since he was frustrated by his failure to get a response from Engineer C. In response to the second question, we feel Engineer B did not participate in any improper behavior. First, we presume, based on the evidence, that Engineer B directed Engineer A to Engineer C in good faith and had no awareness of Engineer C's history of dilatory behavior. Second, we do not believe that Engineer B's revelation of Engineer A unhappiness to Engineer C was a violation of Engineer A confidence. Based on the circumstances, Engineer A appears to have means for Engineer B to inform Engineer C of Engineer A's dissatisfaction, as we have already mentioned. While the data are lacking, we feel Engineer C had a professional duty to communicate with Engineer A about the project progress more directly. Engineer C's action, on the other hand, do not appear to have broken the code of ethics. Finally, while Engineer C looks to need to improve his practice, the circumstances of the case do not show that he was unethical.